Hey, don't move. Step away from the car right now.
Officer, this is my home. What's going on?
I asked you a question. You fit the description, and people like you always think you could talk your way out.
I haven't done anything.
That's what y'all say. Turn around before I make you.
You're making a serious mistake.
6 agents. 3 unmarked SUVs. 1 woman in yoga pants loading a carry-on into her Lexus on a quiet Saturday morning. What they saw was a target. What they got was a federal judge with 11 years on the bench, a keynote speech to deliver in Chicago, and absolutely no intention of letting this go. This is the story of what happened when the wrong people picked the wrong woman, and then tried to cover it up. It didn't work. The time was 6:14 a.m. The neighborhood was the kind that doesn't make noise, not because nothing happens there, but because the people who live there have spent entire careers ensuring that things happen on their terms. Wide lots. Security gates. Streets named after the kind of trees that take 100 years to grow. In Alexandria, Virginia, inside one of the most exclusive gated communities in the D.C. metro area, a black woman stood alone in her driveway, loading luggage into the back of a silver Lexus SUV. Her name was Victoria Lane. She was 54 years old. For 11 of those years, she had served as a United States federal judge, appointed by the President, confirmed by the Senate, assigned to a district bench where she had presided over hundreds of cases involving constitutional law, federal criminal matters, and civil rights. She had sentenced men who thought their power insulated them. She had dismissed charges that political pressure demanded she uphold. She had, in the language of her profession, earned her authority through every ruling she had ever written. That morning, she wore none of it visibly. Yoga pants. A zip-up jacket. Reading glasses pushed up onto her head. A travel mug of coffee sat on the roof of the car. Her carry-on was on the curb. A garment bag hung from the rear door handle. She was heading to Dallas-Fort Worth International Airport to catch a 9:15 a.m. flight to Chicago, a federal judicial conference where she was scheduled to deliver the keynote address on the future of due process and immigration law. Everything about the scene was ordinary. A woman leaving her home on a quiet weekend morning. But before we go any further, if you believe that what happened next was wrong, if you believe that no badge gives anyone the right to do what these agents did, hit that subscribe button right now. Like this video. Drop a comment telling us where you're watching from. Because this story needs to be heard, and your engagement is how it travels. Now let's get back to that driveway. At 6:17 a.m., 3 unmarked black Chevrolet Suburbans turned onto the street and rolled to a stop directly in front of her driveway, blocking the Lexus completely. The vehicles moved in coordinated formation, the kind of approach designed to eliminate escape routes before a subject even registers the threat. 6 agents in full tactical vests exited in practice sequence, hands already positioned, eyes already scanning. Leading them was Supervisory Officer William Jones. Jones was a 17-year veteran of ICE enforcement operations, a man whose file contained commendations and whose unit had a reputation for aggressive fieldwork in the Northern Virginia corridor. He walked toward Lane with the particular confidence of someone who had already decided the encounter's outcome before it began. He cited an active immigration enforcement operation. He said she matched a description. He ordered her to step away from the vehicle. Lane did not raise her voice. She kept her hands visible. She stated her name, her title, and her judicial district clearly and without hesitation. She asked to see a warrant. Jones told her to turn around. There is a specific kind of composure that develops in people who have spent years inside courtrooms, who have watched defendants maintain dignity under pressure, who have seen what panic costs a person in a moment of crisis, and who have internalized, through repetition and discipline, that control of one's bearing is control of one's circumstances. Lane had that composure. She deployed it fully. And it changed nothing. Jones stepped forward. He gripped her arm. He spun her into the side mirror of the Lexus, hard enough that her shoulder would bruise by noon, and pressed her against the hood. The handcuffs were applied quickly, cinched tight. Her face was against cold metal. Her coffee was still on the roof of the car, still warm, untouched. The agents moved to the vehicle. The search was warrantless and immediate. They pulled her suitcase from the cargo area and emptied it on the driveway. They went through her purse. They opened her briefcase, the leather one she carried to every conference, every hearing, every chambers meeting, and spread its contents across the passenger seat. Sealed court documents. Case files bearing federal docket numbers. Materials that, under law, were not subject to warrantless search, not subject to unauthorized review, not subject to the hands of anyone outside the court that had sealed them. One agent photographed them. Not all of them. Specific ones? The selection would matter later. Across the street, a porch light came on. Eldon Pratt was 68 years old, a retired Air Force colonel who had spent 3 decades in uniform and who still, in retirement, kept the disciplined morning schedule of a man who had once commanded others. He stepped onto his front porch in the early gray light, registered what he was seeing, and went inside for his phone. He returned within 90 seconds. He began filming. He called 911. He narrated into both simultaneously, quietly, methodically, the way a man trained to document operational details narrates what he observes. 3 doors down, Beverly Day heard the vehicles. Day was a constitutional law professor at Georgetown, a woman who had spent 2 decades teaching the exact statutes now being violated in plain sight outside her window. She came outside. She identified herself. She cited federal law, chapter and verse, directly to Jones, her phone recording the entire exchange. Jones did not engage with the legal citations. Jones had his own agenda, and it was running on a schedule. He held Lane's judicial ID in his hand at one point, the official federal identification bearing her photograph, her title, her district seal. He looked at it. A silence passed. Then he claimed it could be forged and directed the team to continue. The sweep lasted 11 minutes. When the handcuffs finally came off, there was no apology. No explanation. No acknowledgement that the woman now standing in her own driveway, rubbing her wrists, straightening her jacket, was the same woman whose rulings they would one day need to respect. Jones made a call to his supervisor, agitated, clipped, the tone of a man trying to manage a situation that had already slipped beyond his control. Lane picked up her phone. She turned the camera on herself, on the driveway, on the agents still milling near their vehicles. She narrated clearly, her name, her title, the time, the address, the names of the agents she had been able to read from their vests, the contents they had removed from her vehicle, the documents they had opened, the document she had watched one of them photograph. Her voice did not shake. By 7 a.m., she had sent the recording to 3 people, her chief judge, her personal attorney, and a journalist she trusted. By 7:30, Pratt's footage was on its way to a producer. By 8 o'clock, Lane was still in her driveway. She had missed her flight, and the first calls were already beginning to come in. Jones and his team were already gone. But the morning had recorded everything. And what it recorded was only the surface of what had actually happened. The IC field office on the western edge of the DC metro area was the kind of building designed to be unnoticed. Low-rise, Federal beige, situated between a car parts distributor and a regional shipping depot. By 9 a.m. on the morning of the incident, William Jones was inside it, at his desk, composing the official account of what had occurred on that driveway. What he wrote bore little resemblance to what had happened. The incident report Jones filed described a subject who had been verbally combative, who had initially refused lawful commands, and who had reached toward an unidentified object inside the vehicle before being secured for officer safety. It made no mention of judicial credentials. It made no mention of the briefcase. It made no mention of the sealed court documents that had been spread across the passenger seat, examined, and photographed. The report framed the encounter as a routine enforcement action complicated by subject noncompliance, a clean, procedural narrative with no loose ends. There was one problem. Kyle Rennick had been there. Rennick was 26 years old, 14 months into his first posting with the unit. He was the kind of agent who still cross-referenced his actions against the training manual, who still felt the weight of what the badge was supposed to mean. He had stood on that driveway and watched Jones hold a federal judge's identification in his hands and keep going. He had watched the briefcase being opened. He had watched the photographs being taken. And now he sat across from Jones and read what the report said had happened. Jones slid the document across the desk. The implication was wordless but absolute: sign it, or begin the process of losing everything he had worked toward. Rennick signed it. He drove home. He sat in his apartment for 4 hours. At 9:47 that evening, he called the DHS Inspector General hotline from a payphone at a gas station 2 miles from his building and spoke for 23 minutes. He relayed dates, names, and a detail that would later prove critical: that the operations planning documents had listed Lane's address not as a secondary location or routing error, but as a primary target, flagged 3 days before the operation launched. He requested whistleblower protection before the call ended. The Inspector General's office opened a file before midnight. The FBI's Public Corruption Unit received a referral by Monday morning. By Tuesday, agents had arrived at the field office with federal preservation orders covering all body camera footage, all GPS device logs, all dispatch communications, and all planning documents associated with the operation. Jones cooperated in the way that men cooperate when they believe the record supports them, calmly, almost cheerfully, certain the paper trail said what he needed it to say. It did not. The body cam footage from 3 separate agents, footage that Jones had not reviewed before filing his report, showed Lane's hands raised. It showed her speaking clearly and without aggression. It showed the moment Jones grabbed her arm, the spin into the mirror, the handcuffing. It showed the briefcase being opened. And it showed, at 6:23 a.m., a sequence of 11 seconds in which one agent's body cam inadvertently captured a colleague photographing specific pages from the sealed documents with a personal cell phone, not a department device. The GPS logs placed every vehicle in the unit's convoy at Lane's address. Not 2 miles away. Not in the vicinity of a secondary location. At her address, in her cul-de-sac, from 6:14 a.m. onward. The planning documents were worse. Forensic analysts working with the FBI's digital evidence team identified that the sealed documents photographed from Lane's briefcase corresponded specifically to a federal corruption case she was presiding over, a case involving a real estate development company with contracts touching 4 federal agencies and a political donor network that extended to sitting members of Congress. The case had not been publicly docketed. The documents should have been inaccessible to anyone outside Lane's chambers. Someone had known they would be in that briefcase, on that morning, in that driveway. Meanwhile, Lane sat at her kitchen table with a bag of ice against her shoulder and a legal pad in front of her, reconstructing every detail she could recall in the order it had occurred. She was a judge. She knew how evidentiary timelines worked. She also knew, by the time her chief judge returned her call that afternoon, that what had happened to her was not random. The chief judge's response was immediate. A formal complaint was filed with both the DOJ's Office of Professional Responsibility and the DHS Office of Inspector General. The Federal Judicial Center was notified. A judicial security assessment was ordered for Lane's home and chambers. The machinery of institutional oversight, slow in ordinary circumstances, moved with unusual speed when one of its own had been put against the hood of a car in handcuffs. The neighbor footage went online that same afternoon. Within 18 hours, Pratt's video had accumulated more than 4 million views. Days recording followed. The images were not abstract. A black woman in a zip-up jacket, hands raised, being pressed against her own vehicle by agents who did not stop when she told them who she was. The Senate Judiciary Committee issued a demand for a full briefing within 48 hours of the video's publication. The Congressional Black Caucus released a formal statement condemning what it called textbook racial profiling deployed as an instrument of federal power. The federal judiciary, an institution that rarely speaks publicly about anything, released a statement affirming the independence of its members and the constitutional protections afforded to them. Anonymous communications began reaching Lane's personal email that week. Vague. Untraceable. The kind of messages designed to communicate awareness without leaving a legally actionable record. Someone wanted her to know she had been seen. Someone wanted her to understand that the people who had sent Jones to her driveway had not finished with her. She forwarded every message to her attorney and to the FBI. Then she went back to her legal pad. Now, before we go further, do you think what happened here was a mistake? A wrong address and a bad judgment call? Or do you think this was calculated from the beginning? Drop mistake or setup in the comments right now. Share this story with someone who needs to hear it. The conversation you start might matter more than you know. The question of intent, mistake or setup, was precisely what a federal grand jury would spend the next several weeks trying to answer. And the answer, when it came, would be more disturbing than almost anyone had anticipated. The federal courthouse in Alexandria, Virginia, is a building that takes itself seriously. Marble floors, high ceilings, the particular silence of a space designed to remind everyone inside it that what happens here carries weight. It was in this building, 7 months after the incident on Lane's driveway, that a grand jury returned a sealed indictment against William Jones. The charges were not minor. Deprivation of civil rights under color of law. Assault on a federal officer. Falsification of official government records. Conspiracy to obstruct justice. Each count carried its own sentencing exposure. Together, they constituted the kind of indictment that ends careers and begins prison sentences. Jones was taken into custody on a Tuesday morning, processed, and released on a $250,000 bond by afternoon. His expression in the courthouse footage, captured by a news camera positioned across the street, was the expression of a man who had believed, until that moment, that the institutional walls around him would hold. They had not. Agent Tara Schofield, Jones' second-in-command on the operation, was indicted on related charges that same morning. The evidence against her included body cam footage showing her physically preventing Rennick from stepping toward Lane during the cuffing sequence, and a text message sent from her personal phone to Jones' personal phone 40 minutes after the incident concluded, a message that Forensic Recovery had pulled from a device she had factory reset, incorrectly believing that process permanent. The message contained 4 words. Those 4 words, the prosecution would later argue, constituted consciousness of guilt before any investigation had been announced. Rennick testified under a formal immunity agreement. He sat in the witness chair in a suit that looked like it had been purchased for the occasion and spoke for 2.5 hours. He described the planning meeting 3 days before the operation, during which the target list had been reviewed and Lane's address had been listed without the standard immigration docket annotation that should have accompanied any enforcement action. He described the moment on the driveway when he had seen Jones examine the judicial ID and continue anyway. He described the briefcase. He described watching the photographs being taken. He described the incident report being placed in front of him, the silence in the room, and his own hand signing a document he knew to be false. His voice, witnesses later said, did not waver. The prosecution built its case methodically, the way prosecutions built on documentary evidence tend to be built, layer by layer, each piece placed in deliberate sequence. The body cam footage came first, 3 synchronized feeds playing simultaneously on screens positioned so that the jury could see every angle at once. The footage showed what it showed. Lane's hands raised. Her credentials presented. The grab. The spin. The hood. The briefcase opened. The photographs taken. Then came the planning documents. Then the GPS logs. Then the forensic analysis connecting the photographed pages to the corruption case on Lane's docket, a case that had been sealed at the request of federal prosecutors who were building a parallel criminal referral against a real estate development company whose principals had donated, across a 4-year period, more than $2.3 million to federal political campaigns. The connection between the documents and the developer had required significant forensic accounting work to establish. The prosecution established it anyway. Eldon Pratt testified about what he had seen from his porch. His account was precise. Times, positions, sequences, the kind of testimony that comes from a man trained to observe and report. Beverly Day testified about the federal statutes she had cited to Jones on the driveway and his failure to respond to any of them. Both witnesses described Lane's composure. Both described the moment Jones held the judicial ID. Both described the decision to continue. Lane testified last. She took the stand in a dark suit and spoke without notes. She described the physical experience of being pressed against the hood of her car, the temperature of the metal, the tightness of the cuffs, the way she could hear her neighbors' voices without being able to turn toward them. She described the professional calculation she had made in real time: stay calm, say everything aloud, let the record accumulate. She described the moment she understood, weeks later, reviewing the case files on her own docket, that the documents photographed from her briefcase were the same documents that had since appeared, in summarized form, in communications recovered from the developer's legal team, communications predating any public disclosure by 6 weeks. She had not been profiled randomly. She had been targeted specifically. The profiling had been the method. The documents had been the objective. The defense argued operational stress, mistaken identity, and good faith judgment in a high-pressure environment. It was a coherent argument. The jury did not find it persuasive. Deliberations lasted 6 hours and 14 minutes. Jones was convicted on all counts. At sentencing, the district court judge, not Lane, who had recused herself from any proceeding connected to the matter, looked at Jones across the courtroom and delivered a ruling that would be quoted most frequently in subsequent coverage: that what had occurred was not an error of training or an excess of zeal, but a deliberate corruption of federal authority for the benefit of private interests. Jones received 7 years. Schofield received 3. The field office supervisors who had approved the operation without standard warrant verification were referred for administrative proceedings that resulted in demotions and, in 2 cases, forced retirement. Lane filed her civil suit against DHS and IC the week after sentencing. Discovery in that case produced what the criminal trial had suggested but not fully exposed: a documented pattern of complaints against Jones' unit dating back 4 years, complaints that had been reviewed, logged, and closed without action by supervisors whose own communications, now subpoenaed, showed awareness of the unit's methods. The communications also contained a reference, oblique, deniable, but present, to a contact within the unit who had been in communication with a representative of the developer's legal team in the weeks before the operation. The settlement came 8 months later, $4.6 million. Mandatory Civilian Oversight Board for Enforcement Operations in the District. Mandatory Warrant Verification Protocols. Mandatory anti-bias training with external auditors. A requirement that body camera footage from all operations be uploaded to a secure federal server within 1 hour of an operation's conclusion. A requirement specifically designed to close the window in which footage could be reviewed and selectively preserved. The additional probes into the developer's political network were ongoing. They remained ongoing. William Jones reported to federal prison on a Wednesday morning in October. He arrived in a private vehicle, accompanied by his attorney, carrying a single bag. The pension he had accrued over 17 years of federal service was forfeited under the civil asset provisions attached to his conviction. His federal law enforcement certification was permanently revoked. The career he had built, the authority he had exercised, the institutional protection he had relied on, all of it ended at the facility's intake desk on a Wednesday morning in October, in the administrative way that consequential things sometimes end. Tara Schofield did not report to prison. Her sentence, reduced in exchange for cooperation with the ongoing developer probe, was converted to home confinement followed by supervised release. She was barred from federal employment permanently. The 4 supervisors who had signed off on the operation without warrant verification were demoted. 2 were forced into early retirement. None of them contested the findings publicly. Kyle Rennick received a formal commendation from the DHS Inspector General's office, a certificate, and a letter entered into his permanent personnel file, acknowledging that his disclosure had been essential to the integrity of the subsequent investigation. He was transferred, at his request, to a posting in the Pacific Northwest. He gave no interviews. He made no public statements. He had done what he believed was right, and he appeared to have made his peace with the cost of doing it. Victoria Lane returned to the bench on a Monday. She had taken a formal leave of absence during the criminal proceedings, a decision made in consultation with the Chief Judge and the Federal Judicial Center, designed to insulate the integrity of both her active docket and the prosecution. When she returned, Her courtroom was the same courtroom. The docket had continued without her. The work had accumulated. She sat down and began working through it. Outside the courthouse, she moved differently through the world, not with fear, but with the specific alertness of someone who understands, now from direct experience, that the structures designed to protect people sometimes require the people themselves to protect those structures. The anonymous communications had stopped after the indictments were unsealed. The threats, such as they were, had receded. The developers' network was under active federal scrutiny, and people under federal scrutiny tend to become conservative in their communications. The Lane Justice Initiative was incorporated 3 months after her return to the bench. It was not a large organization. It was not designed to be. It was a legal aid fund, specifically structured to provide representation to individuals who had experienced unlawful enforcement actions, warrantless searches, improper detentions, the particular category of violations that tend to go unchallenged not because they are defensible but because the people who experience them cannot afford to fight. Lane funded the initial endowment herself. She recruited 3 attorneys she trusted. She established a board that included Eldon Pratt and Beverly Day. She did not hold a press conference. The initiative's first 3 cases were filed quietly, in federal district courts, on behalf of people whose names most Americans would never know. The agency reforms moved through implementation on the federal timeline, which is to say, slowly, unevenly, with the particular friction that institutional change generates when the institution being changed is also the institution responsible for implementing the change. The warrant verification protocols were adopted. The body camera upload requirement was adopted. The Civilian Oversight Board was constituted, staffed, and operational within 14 months of the settlement. The training modules, built around the footage from Lane's driveway, the body cam feeds, the neighbor recordings, were integrated into the mandatory curriculum for IC enforcement personnel across 6 regional offices. Agents in those training sessions watched the footage in silence. The footage was not edited. It was not framed with commentary. It was simply played, in sequence, and then the facilitators asked the agents what they observed. The conversations that followed, by the accounts of the facilitators who ran them, were not comfortable. They were not supposed to be. Lane was invited to speak at the Federal Judicial Conference in Chicago, the conference she had been traveling to when the Suburbans pulled into her cul-de-sac. She accepted. She traveled on a Tuesday morning, through an airport, with her carry-on and her garment bag and a travel mug of coffee. She arrived without incident, the way people are supposed to arrive at airports. She spoke for 38 minutes without notes. She did not frame it as a story of what had been done to her. She framed it as a story of what the system had done, to itself, through its own failures, and then, slowly, through the efforts of people who refused to let those failures stand as the final word. She credited Pratt. She credited Day. She credited Rennick, by name, explicitly, with the particular weight of someone who understands what naming a person in that context costs them and means to them. She said that justice, in her experience, moved the way that truth moves, not spectacularly, not all at once, but in accumulation, each documented fact adding to the weight of the record until the record becomes undeniable. The driveway in Alexandria was still a driveway. The Lexus was still there. The coffee mug was long gone. But the cul-de-sac had been, in the months since the verdict, the subject of a quiet, informal pilgrimage, people who had seen the footage driving slowly past, stopping briefly, looking at the unremarkable strip of concrete and thinking about what had happened there, and what it had cost and what it had, eventually, produced. Some places become symbols not because anything was built there but because something was refused there. Victoria Lane had been pressed against the hood of her car on that driveway and told, in every way but words, that she did not matter enough to be believed. She had decided, in real time, that the correct response to that was documentation. She had been right. Stories like this one don't leave you easily. The details that stay with you, the cold metal, the 11 minutes, the photographs being taken of documents that were never supposed to leave chambers, these are the things that surface at 2 a.m. when the room is quiet and everything else has settled. If you've been lying awake processing what you've heard tonight, you're not alone. And if disrupted sleep has become a pattern for you, not just tonight but in general, there's something worth knowing about. The link in the description takes you to a 30-day uninterrupted sleep reset program built on sleep science research, a method for retraining the brain toward consistent, restorative rest. Check it out. Take care of yourself. And if this story moved you, share it. The people who need to hear it are out there.